request everyone to please turn their phones on silent or switch them off. Can I also request the people on the dais to come join us for the lighting of the lamp? May I now request our youngest family members who are in audience, because now we have much younger ones as well, Krishna and Anisha, to come and give the plants. Justice B.R. Gavai, Chief Justice of India, who will deliver this year's memorial lecture. Justice Upadhyay, Chief Justice, Delhi High Court. Justice Lokul, judges, lawyers, social activists, students, members of civil society, representatives of the media, ladies and gentlemen. I welcome you all to the 30th Sunanda Bhandare Memorial Lecture this evening. Since 1995, the Justice Sunanda Bhandare Foundation has organized an annual lecture on issues that were close to my grandmother's heart, specifically gender justice, human rights, especially child rights and the rights of women and differently abled persons. In our second lecture since Baba's passing, we remain committed with your love and support to endeavor to fill his shoes. He was our driving force. Murli's favorite riddle was Sunanda became an MA before she became a BA. Any guesses? She became a mother before she got her degree. In the past, distinguished persons like late Justice V.R. Krishna Iyer, late Dr. APJ Abdul Kalam, Professor Amartya Sen, Mrs. Sonia Gandhi, His Holiness the Dalai Lama, and Nobel laureate Kailash Satyarthi delivered lectures on different topics. Earlier this year, Ms. Indira Jaising, senior advocate and one of our dearest members of our family, delivered the 29th Justice Sunanda Bhandare Memorial Lecture on India's modern constitutionalism. The foundation has fought a long-standing litigation before the Supreme Court to ensure the practical and effective implementation of the law for persons with disabilities and the 2016 Act. Our speaker this evening, Justice B.R. Gavai, Chief Justice of India, has been a Chief Justice who has been admired by members of the bar, especially the junior members, and has given great encouragement to younger members by not allowing senior advocates to mention matters. The topic for today's lecture is Justice for All, Building a Gender Equal and Inclusive India, which has acquired great significance in the context of today's climate of intolerance. I welcome you, Justice Gavai, and we look forward to your lecture. One of the more glaring examples of the subjugation of women is the manner in which they are treated within the home and the mindset within the home, which dissuades them from even knowing their rights, much less having access to remedies. A change of mindset within the home is the need of the hour so that women are allowed the freedom to choose and the right to excel, our foundation's motto. This allows women to be the change makers and decision makers, greater inclusivity of women in positions of power, be it as judges or elected representatives, changes outdated mindsets, and we lead by example rather than on paper alone. The inclusivity of not just women, but other minorities is a cause that is being fought today, and women are taking control of their rights and seizing the opportunity to demand equality that should have been an inherent and fundamental moral right. I accord a warm welcome to Justice Upadhyay, Honorable Chief Justice, Delhi High Court, who is presiding over this function. He has been a great support to the foundation. Last but not least, I welcome you all, students, teachers, lawyers, members of the civil society, media persons and volunteers, whose unstinting support has encouraged and motivated us to carry forward the work my grandmother started. May I now request Justice Lokur to give our opening remarks.
Thank you, Shreya. Good evening, everybody. Honorable Chief Justice Gavai, Honorable Chief Justice Upadhyay, Honorable Judges of the Supreme Court, and Honorable Judges of the Delhi High Court, former Judges of the Supreme Court and the Delhi High Court, senior advocates, distinguished ladies and gentlemen. Welcome to the 30th Justice Sunanda Bhandare Memorial Lecture. As far as I am aware, the Justice Sunanda Bhandare Memorial Lecture Series is probably the longest surviving lecture series concerning social issues and jurisprudence. The Tagore Law Lectures, organized by the University of Calcutta, began in 1870 and continued on a regular basis. Unfortunately, the lectures became irregular from 1951 onwards and eventually stopped in 1986. For today's lecture, we are fortunate to have Chief Justice Gavai, Chief Justice of India, to speak on justice for all, building a gender equal and inclusive India. This is a subject close to Justice Bhandare's heart. Among the many cases on gender equality argued by Justice Bhandare as a practicing lawyer in the Supreme Court, I would like to mention the case of Bai Tahira versus Ali Hussain Fisali Chotia, AIR 1979, Supreme Court 362, in which the Supreme Court ruled that a divorced Muslim woman was entitled to maintenance from her former husband. This was a precursor to the more famous Shah Bano case, which is once again a current topic of discussion with the release of the movie Haq. Justice Sunanda Bhandare was appointed a judge of the Delhi High Court on 1st June 1984 at the young age of 41. It is widely acknowledged that given her legal acumen, her impartiality and dedication to the cause of justice, it was only a matter of time when she would be appointed a judge of the Supreme Court and then the first woman Chief Justice of India. Unfortunately, that was not to be, since she passed away on 10th November 1994, again at a relatively young age of 51, when she was among the senior most judges in the Delhi High Court. Justice Bhandare had a passion for justice and social change. She could achieve these twin objectives largely because she had her feet firmly on the ground. An example of this is her visits to INA market for vegetable shopping and for the purchase of groceries. The joke among the shopkeepers, with respect and affection, was that "Aaj Adalat sabzi kharidne aayi hai." Justice Bhandare attended court and performed her duties with responsibilities, with dedication, even after she was diagnosed with cancer. She attended court regularly and had a ramp constructed at court number 2, making it convenient for her to go up the rostrum and hold court. I recall having appeared before her during that period almost every day. Despite her physical condition, she remained in good spirits and wanting to work. In fact, just a few days before her visit to London for treatment, she delivered a 78-page judgment on an issue concerning the dismissal of army personnel without giving reasons. The judgment was challenged in the Supreme Court, but her view was upheld. Beyond her life as a lawyer and a judge, Justice Bhandare had a range of interests. She was an active participant in international conferences. In 1975, she was one of India's delegates to the first International Women's Conference in Mexico. In 1989, she presented a paper on judges as instruments of social change at the Conference of National Association of Women Judges in Washington. She had great love for art and music. Her art collection included the works of renowned artists such as N.S. Bendre, K.H. Ara, J. Swaminathan, B. Prabha, B. Vitthal, Jatin Das, as well as a host of younger artists admired by connoisseurs. She surrounded herself with the echoes of classical music, and her day never ended without listening to the soothing strains of a rag. On important occasions in her life, like the marriages of her children, her 50th birthday, and the birth of her granddaughter, she celebrated with performances by formidable artists such as Pandit Bhimsen Joshi, Pandit Jasraj, Shubha Mudgal, and Farida Khanun. Now, a few words about the Justice Sunanda Bhandare Foundation. The motto of the foundation is freedom to choose, right to excel. It was established in 1995 by her husband Murli Bhandare, senior advocate and former governor of Orissa. Murli Bhandare passed away last year on 15th June 2024 at the age of 95. Over the last several decades, the foundation has organized annual memorial lectures graced by luminaries from all walks of life, as mentioned by Shreya. These lectures have been on themes close to Justice Bhandare's heart namely relating to gender justice and the rights and empowerment of women. Over the years, these lectures have enriched our understanding of the rights of women and what can be done to empower women and advance their rights. In addition to the memorial lectures, the Foundation has conducted several legal awareness programs attended by over 1 lakh men and women. These programs have been conducted by advocates, professors of law, counselors, activists, and law students. In many of these programs, free legal aid has been given to the participants. The Foundation has donated funds to Delhi University to award a gold medal titled Justice Sunanda Bhandare Gold Medal in Family Law to a student who secures the highest marks in family law. In addition, the Foundation has also created an endowment for the award of a fellowship of 1,500 rupees per month in the name of Justice Sunanda Bhandare Fellowship in Constitutional Law to a student securing the highest marks in constitutional law. In 2012, the West Bengal National University of Juridical Sciences in Kolkata established a Justice Sunanda Bhandare Forum for Natural Resources Laws to facilitate research and publication and organize training programs. The Foundation has been quite active this year also. The 29th Memorial Lecture was held on 21st February 2025. The delay was occasioned by the sad demise of Murli Bhandare last year. The topic of the lecture was India's Modern Constitutionalism and was delivered by Senior Advocate Indira Jaisingh. More recently, a conference was organized on 2nd August 2025 in association with Q-Able on the topic Judging and Lawyering at the Margins, Disability Rights and Beyond. The subjects discussed in the conference included lawyering for clients with disabilities, lawyering for women with disabilities, and queer and disabled lawyering at the margins. Through the lived experiences of lawyers with disabilities, the conference achieved its objective of generating a dialogue on ethical, accessible, and inclusive lawyering, as well as creating a platform for disability and queer inclusive legal discourse. The conference was able to identify barriers in the legal ecosystem and brainstorm systemic solutions by building solidarity across movements and professional roles. With these few words, I once again welcome you to the 30th Justice Sunanda Bhandare Memorial Lecture.
May I request Justice Upadhyay to come and give his remarks.
Honorable the Chief Justice of India, Justice B.R. Gavai, Justice Varale, Judge Supreme Court of India, Justice Madan Lokur, Chairman, Justice Sunanda Bhandare Trust, my sister and brother judges of High Court of Delhi, present and former, other judges from other high courts, Shri Rahul Bhandare, Managing Trustee of the Foundation, Ms. Manali Singhal, Trustee, former Attorney General for India, Shri Mukul Rohatgi, Mr. Hariharan, President, Delhi High Court Bar Association, lawyers, students, and all others who are in attendance today. I wish you all a very good evening. It is a matter of great honor and privilege for me to deliver this address at the 30th edition of Justice Sunanda Bhandare Memorial Lecture. Lawyers and judges may have numerous distinguishing features, but they are alike on this day. The footprints of their legacies could be traced both inside and outside the courtroom. Even years after they leave us, Justice Bhandare may not have stepped inside the courtroom, after her untimely demise in the year 1994, but her legacy lives on outside the courtroom till date, and this gathering is a living testament of that. Justice Bhandare was a stalwart in the field of gender equality, and the ideal of equality influenced her work greatly, both inside and outside the courtroom. A dive into her life shows that her thought process was a result of her lived experiences. She belonged to a distinguished legal family which was at the center of the constitutional developments of their time. She was the daughter of Sri H.R. Gokhale, former law minister and member of parliament, and partner of one of the finest constitutional practitioners of his times, Sri M.C. Bhandare, senior advocate, who unfortunately passed away last year. Justice Bhandare was a strong proponent of the constitutional principles of equality, and she advocated the substantive equality in all walks of life. In addition to her belief system, what is more remarkable is that her choice of weapon was always the Constitution, and she led by example by upholding the constitutional ideals in her functioning as a judge. At the same time, Justice Bhandare always made sure that the sanctity of the process is never compromised in search of desirable results. More often than not, the difficulty before the judges is not to find the right answers, but to ensure that the process adopted by them in the search of right answers is equally worthy and right. The sanctity of judicial process lies in the reasonableness of our procedures, and we deviate only when excessive adherence to procedures tends to suppress the cause of justice. Today, it is a moment of great honor that Honorable the Chief Justice of India is delivering the lecture on the topic of great contemporary importance. His own journey in the profession is remarkable, and he has been a true icon of inclusivity. Throughout his career, both on and off the bench, he has played a dynamic role in building a truly inclusive society. His keen sense of ground realities and lived experiences have enabled him to understand the nuances of equality and equal justice for all in an unparalleled manner. The real growth of a country is not solely dependent upon its economic power. Rather, it is equally dependent upon the inclusive character of the society. Inclusivity ensures that the development of a nation is sensed even by the last person standing in the queue, and the ideal of justice bears a close connection with the notion of inclusivity. Today, it is heartening to note that we find ourselves in an advanced age of equality jurisprudence. The concept of discrimination, as we traditionally understood, is evolving. The concepts of direct and indirect discrimination, substantive equality, etc., have received judicial recognition in the last few years, and we are on a trajectory to address even the most nuanced inequalities prevailing in the society. Today, as we celebrate the life of Justice Bhandare, it would be safe to say that she would have rejoiced on the role that the judiciary has played for ensuring justice for all. No doubt, it is a work in progress. However, what matters most is that we remain ready for the challenges that society brings on our table, and the sense of constitutionalism continues to gain ground in the society, not only inside but also outside the court. Justice Bhandare would also have been delighted to see the increasing representation of women in the profession, especially in the district judiciary. Justice Bhandare may have left us well before time, but her ideas and ideals live on and continue to show the way. On this note, I thank the Foundation for having me here today. It was a privilege and honor to be here with you all. Thank you. Thank you very much.
May I now invite Justice Gavai to give the 30th Justice Sunanda Bhandare Memorial Lecture.
Honorable Justice B.K. Upadhyay, the Chief Justice of Delhi High Court, Honorable Justice Madan Lokur, the President of the Trust and former Judge of the Supreme Court, my esteemed colleague Justice Varade, sitting and former judges of the Delhi High Court, Shri Praful Patel and Shri Anand Sharma, the members of Parliament, Shri Mukul Rohatgi, the former Attorney General for India, Shri Hariharan, the President of the Delhi High Court Bar Association, Ms. Pratnya Baghel, the Secretary of the Supreme Court Bar Association, the other office bearers of the Delhi High Court Bar Association, the Supreme Court Bar Association, KORA, the senior advocates from Delhi High Court and the Supreme Court present here in large number, the members of the bar, the friends from media, academicians, students, the family members of late Justice Sunanda Bhandare and my father's friend Sri Muralidhar Bhandare, Rahul and Manali. While coming here, I was reflecting on how there are certain individuals we may never have had the opportunity to meet in person, yet their life and work leave a profound and lasting impact on us. They shape the way we think, inspire the values we hold dear, and influence our sense of purpose in ways that transcend time and distance. For me, late Justice Sunanda Bhandare is one of such remarkable personality. Her life continues to resonate as a symbol of courage, compassion, and commitment to justice. Therefore, it is indeed a matter of great honor and privilege to deliver the 30th Justice Sunanda Bhandare Memorial Lecture. Over the years, this platform has been graced by some of the finest legal minds and thought leaders of our time, judges, jurists, scholars, and social reformers, each contributing invaluable insights on questions that lie at the intersection of law, justice, and social transformation. Standing here today, I am deeply conscious of such a rich legacy. To be able to add my voice in however modest a way to this ongoing conversation is both humbling and deeply meaningful. Let me begin by remembering the extraordinary life and legacy of Justice Sunanda Bhandare. She was a rare and luminous blend of intellect, grace, and courage, qualities that defined not only her judicial career, but her entire life's journey. Born on 1st November 1942, in the year that witnessed the stirring of the Quit India movement, she was in many ways a child of freedom, both in spirit and in conviction. The ideals that animated India's struggle for independence, such as equality, justice, and the belief in human dignity, were deeply interwoven into her worldview and later reflected in her approach to law and life. Justice Bhandare came from a lineage that embodied public service and integrity. Her grandfather, R.H. Gokhale, served as the Chief Justice of the Baroda High Court, establishing a legacy of legal erudition and fairness. Her father, Hari Ramchandra Gokhale, was a freedom fighter who carried forward those ideals into the newly independent nation, first as a judge of the Bombay High Court and later as a Union Minister for Law. From such a family, she inherited not just a familiarity with the law, but a moral sense that justice is not a privilege to be exercised by a few, but a duty owed to every citizen. The legacy shaped her understanding of the law as an instrument of social change rather than mere technical interpretations. Her upbringing amidst freedom fighters, jurists, and reformers imbued her with an intrinsic empathy for the marginalized and a deep awareness of transformative power of the justice. At the young age of 26, Justice Sunanda Bhandare was enrolled with the Maharashtra Bar Council, a remarkable achievement at a time when very few women entered the legal profession. In 1970, she moved to Delhi, embarking on what would become a trailblazing journey in the corridors of the Supreme Court of India and Delhi High Court. It was an era when the presence of women in courtrooms was still a rarity and even more so in advocacy roles. The profession, while steeped in notions of justice and equality, often reflected the very hierarchies it sought to dismantle. Courtrooms carried an unspoken but palpable sense of gendered hierarchy. Opportunities were limited, visibility was harder earned, and every success demanded not just skill and intellect, but resilience and resolve. Justice Bhandare faced these challenges with quiet strength and dignity. She navigated a male-dominated profession with perseverance and grace, building a reputation not through rhetoric, but through a sheer quality of the work. Her sharp legal acumen, coupled with a calm and composed demeanor, earned her the respect of her peers and the confidence of the bench. In doing so, she became not just an advocate of her clients, but a symbol of what women could achieve in spaces that had long been closed to them. Colleagues remember her as a dependable, prepared and compassionate, especially towards those who could not afford strong representation. She appeared in Bai Tahira versus Ali Hussain Fisali Chotia case in 1979, a case about the right of a divorced Muslim woman to receive maintenance from her former husband. It was referred to by Justice Lokur. Justice V.R. Krishna IA's judgment in the matter affirmed that right. Justice Bhandare's arguments in this case spoke to her conviction that no faith can justify the abandonment of justice. Around the same time, she also took up a case that was ahead of its time: the inclusion of women in the armed forces. She did not succeed then, but she had the courage to ask the question when it was least inconvenient. That dream was carried forward in Union of India versus Babita Punia and Lieutenant Colonel Nitisha versus Union of India, where the Supreme Court held that women officers must be granted equal opportunity and command roles in the armed forces. Those judgments, in many ways, complete a circle that began decades ago. What was once an argument from the bar has now become a constitutional commitment. I must also take a moment here to commend not just Justice Bhandare, but also her husband, the late Governor Muralidhar Bhandare, who was Murli Kaka for me, and who shared Justice Bhandare's commitment to social justice. In his memoir, he has narrated about the family's resolve to social justice. He has shared how his father invited Dr. B.R. Ambedkar to his family. Let me quote an excerpt from his memoir, and please bear with me as it is a long narration. I quote, Dr. Ambedkar had wanted to visit the burial site of the great Bhakti poet and saint Chokha Mela, who is buried at the footsteps of the Vitthal temple at Pandharpur. But he was denied entry because, like Chokha Mela, Dr. Ambedkar was a Mahar. Mindful of this shameful denial of entry, in 1936, my father invited Dr. Ambedkar to visit our family temple of Sri Thakurji Muralidhar. Accompanied by leading figures like Yamar Jayakar, a member of the first Privy Council of India, N.V. Gadagi, a freedom fighter, writer and politician, who later served as a minister in the first Union cabinet after independence, and also as governor of Punjab, Anantahari Gadre, Rambhav Mandlik, Rambhav Tatnis, and about 100 other Dalit followers. Dr. Ambedkar entered the temple. To the best of my knowledge, ours was the first temple in India which was open to Dalits. Someone asked Dr. Ambedkar about why he was so passionate about temple entry of Dalits, to which he replied, "The issue is not entry, but equality." I was not yet 8 years old, but even today, vividly remember standing by my father's side to receive and welcome Dr. Ambedkar. He was not a very tall man, but I remember looking up and thinking how big he was. What a deep impression that historic visit made on my mind and in my heart. I believe it had an abiding influence on my liberalism it led to a determination in me to become a responsible citizen, caring equally for all sections of society. Dr. Ambedkar used to come regularly on Saturdays to the office of Vivid Vrit, a Marathi weekly, situated in our neighborhood. The weekly was brought out by Rambhav Tatnis. Many progressive leaders of Maharashtra would sit there and discuss the past, present, and future of the country. I worked ceaselessly against the practice of untouchability. This determination to create an equitable society governed the actions of both Muralidhar Bhandare and Justice Sunanda Bhandare. Though I did not have an opportunity to personally meet Justice Sunanda Bhandare, I have had a long-standing association with her family, particularly Shri Muralidhar Bhandare, who was a very close friend of my father, and their son Rahul and daughter Manali. As a matter of fact, we reside in the same building at Mumbai. My father and Shri Bhandare shared a bond through their common public life. Both served as members of the Rajya Sabha. Just Mr. Anand Sharma was telling me that he was also a member of Rajya Sabha during that period. Their shared commitment to public service and constitutional values often brought their paths together in spirit. When my father served as the governor of Kerala, Shri Bhandare held the gubernatorial office in Odisha. I also fondly recall that when I was appointed as a judge of the Supreme Court, Shri Bhandare extended his warm blessings and words of encouragement. His grace, humility, and deep respect for the judiciary have always remained with me as a source of inspiration. I recollect when last year I had delivered a speech on Dr. Ambedkar and his contribution to the Constitution. He came to the auditorium in a wheelchair to attend my lecture. I was really moved by his gesture. As a judge of Delhi High Court, Justice Sunanda Bhandare was known for her independence, fairness, and simplicity. She truly believed that law was a tool for social progress, not a preserve of privilege. Her judgments were marked by compassion. Her courtroom was brisk but kind. Young lawyers called her the mother bench because she listened, she guided, and she corrected with care. Let Governor Muralidhar recall that despite being passionate about her work, Justice Bhandare continued to enjoy her hobbies throughout her career and even after her elevation to the bench. At times, she would rush straight from the court to attend an Ikebana exhibition so that she could improve her own flower arrangement skills. A passionate lover of art, she would often deny herself some things just to save money for a painting she liked. Her collection included works of renowned artists like Bhandare, Ara, J. Swaminathan, B. Prabha, B. Vittal, M. F. Hussain, Jatin Das, as well as that of a number of young emerging artists. A connoisseur of Hindustani classical music, she celebrated the most significant occasions in her life: the marriage of her children, her 50th birthday, and the birth of her granddaughter, with performances by eminent artists such as Pandit Bhimsen Joshi, Pandit Jasraj, and Shruti Sadolikar. When illness came, Justice Bhandare did not retreat. In 1992, she was diagnosed with a multiple myeloma. She made her doctors promise that they would add life to her years, not years to her life. Even when the disease made it difficult to move, she asked the High Court to build a ramp so she could enter on a wheelchair. 2 days before she left for her final treatment in England, she presided over a full bench in a complex army matter. Despite her pain, she wrote a 78-page judgment striking down an old army regulation that allowed dismissal of personnel without reason. That judgment, later affirmed by the Supreme Court in Union of India versus ex-Major N.R. Ajwani, became a landmark for liberty and procedural fairness. It was her last act of service to ensure that no one, soldier or civilian, would lose livelihood without cause. She passed away on 10th of November 1994, just after her 52nd birthday. Her passing left a silence, but her ideas, especially on gender equality, continue to echo even today. Let me draw a comparison here. Justice Bhandare's formative years at the bar coincided with the rise of Ruth Bader Ginsburg in the American legal world. Both were women of extraordinary intellect, conviction, and courage, who entered the legal profession at a time when few women dared to dream of such paths. Like Justice Ginsburg, Justice Bhandare combined deep legal insight with a passionate commitment to equality and justice. I say this without exaggeration. Had fate not intervened so cruelly and claimed her life too soon, Justice Bhandare would have gone on to achieve accomplishments as remarkable as those of Justice Ginsburg. Her vision, clarity of thought, and empathy for the marginalized had already set her apart as one of the most promising legal minds of her generation. Her legacy is now carried forward by her daughter Manali Singhal, who is a lawyer at the Supreme Court, and her granddaughter Shreya Singhal, who is also a lawyer. Most notably, Justice Bhandare's fighting spirit is evident in the PILs filed by her granddaughter, which have led to landmark judgments such as Shreya Singhal versus Union of India, where the Supreme Court declared Section 66A of the Information Technology Act 2000 unconstitutional for violating the rights of freedom of speech and expression guaranteed under Article 19(1)A. I extend my best wishes to her family. Let me now turn to the theme of my address today, Justice for All, building a gender equal and inclusive India. To meaningfully explore this subject, I have chosen to trace our history in three distinct phases of 25 years each, beginning from 1950, the year our Constitution came into force. Each of these phases represent a crucial stage in India's constitutional evolution. The early years of nation building and rights realization, the period of social and judicial transformation, and the contemporary era where the equality and inclusion are being reimagined in the light of new challenges and aspirations. Through this lens, I hope to reflect on how far we have traveled in realizing the constitutional promise of justice for all and how much further we must go to build a truly gender equal and inclusive India. When the Constitution of India was being drafted, the framers were actually conscious of the deep-rooted social inequalities that had long structured Indian society, whether on the basis of caste, class, or gender. They understood that the idea of justice would remain incomplete unless equality was made both a constitutional ideal and a lived reality. Therefore, the Constitution's framers enshrined powerful guarantees in the Fundamental Rights chapter. Article 14 lays the foundation by proclaiming that every person is equal before the law and entitled to equal protections of the law, a principle that has since guided our democracy's moral compass. Article 51 goes further to expressly prohibit discrimination on several grounds, including sex, thereby acknowledging gender-based disadvantage as a constitutional concern. Importantly, Article 15(3) authorizes the state to make special provisions for women and children. This clause was not merely a gesture of goodwill, it was a deliberate constitutional design to ensure that affirmative and protective measures for women's advancement would have clear legal legitimacy in the years to come. Long before many other democracies extended equal protection and political rights to women, India's constitution adopted universal adult franchise from the very beginning. Every woman in independent India stood equal to every man in the exercise of her most fundamental democratic right, the right to vote. In doing so, our constitution laid down one of the strongest foundations for gender equality and justice, transforming the promise of equality from a moral aspiration into a constitutional guarantee. Among the directive principles of the state policy, Article 39A directs the state to ensure that men and women have equal rights to an adequate means of livelihood. Article 39D requires the government to ensure that men and women are paid equally for equal work. Further, Article 42 requires the state to provide not just on human conditions of work and for maternity leave. Building upon the constitutional guarantee of equality and non-discrimination, the early decades after independence witnessed a transformative wave of legislations aimed at reshaping women's position in both the private and public spheres. Guided by the vision of the constitutional framers, these reforms sought to translate formal equality into substantive empowerment. The most far-reaching among them were the Hindu Code Bill, a monumental legislative project that redefined family relations, inheritance, and property rights for millions of women. Spearheaded by Dr. B.R. Ambedkar and later carried forward by successive leaders, these laws marked the first systematic attempt to align India's personal laws with the constitutional ideas of justice and equality. The Hindu Marriage Act 1955 introduced a revolutionary changes by granting women the right to divorce and remarry, which were rights previously denied under orthodox religious laws. It outlawed polygamy and child marriage, recognizing women as an equal partner in marriage and not merely as dependents within it. The Hindu Succession Act 1956 further advanced gender justice by conferring upon women full ownership rights in property and recognizing daughters and widows as equal heirs. By abolishing the limited estate doctrine, it transformed women's rights from mere life interest to absolute ownership as an emphatic assertion of economic agency. The Hindu Adoption and Maintenance Act 1956 extended the power of adoption to women and secured their right to maintenance, including post-divorce support, affirming women's capacity for independent decision-making and economic security. Complementing this, the Special Marriage Act 1954 offered a secular framework for marriage, facilitating unions across caste and religious boundaries. In doing so, it recognized women's autonomy in choosing their life partners and challenged entrenched social hierarchies that had long constrained their freedom. The Dowry Prohibition Act 1961, by criminalizing the giving of and receiving of dowry, sought to address one of the most pervasive and violent manifestations of patriarchy in Indian society. Though enforcement remained weak, it marked an important acknowledgement by the state that marriage could not be a site of coercion or commodification. Similarly, the Maternity Benefit Act 1961 established women's right to maternity leave and protection from dismissal during pregnancy, recognizing reproductive health as an inseparable component of workplace equality and dignity. Collectively, these enactments represented not only legal reform, but a moral and social reconstitution of Indian society. They sought to dismantle the structural inequalities embedded in family and custom, bringing women from the margins of dependency to the center of constitutional citizenship. While their implementation encountered resistance and uneven progress, these laws laid the groundwork for the ongoing struggle towards gender equality, transforming the promise of the Constitution into a living reality for generations of Indian women. I'll come to the second phase between 75 to 2000. After 1975, the national discourse on gender equality began to evolve beyond questions of formal rights, turning instead towards the deeper idea of dignity as an inseparable component of equality. The conversation shifted from a mere legal parity to the recognition of the woman's autonomy, bodily integrity, and the social realities that shape their lived experiences. A defining moment in this transformation, though one born out of a tragedy and institutional failure, was the Supreme Court's judgment in Tukaram versus State of Maharashtra, popularly known as Mathura case. In this case, the Supreme Court acquitted two policemen accused of raping a young tribal girl inside a police station, reasoning that her consent was voluntary because there were no visible marks of physical resistance. The judgment reflected a deeply regressive and patriarchal understanding of consent, effectively denying the social context of power, coercion, and vulnerability in which sexual violence often occurs. In my view, this decision remains one of the most troubling moments in India's constitutional and judicial history, and it could be called as a moment of institutional embarrassment, where the legal system failed to protect the dignity of the very person it was meant to safeguard. Yet this judgment also became a turning point. The public outrage and the nationwide protests that followed, led by women's groups, students, and legal activities, ignited the modern Indian women's rights movement. It compelled the nation to confront the inadequacies of its criminal law and catalyzed the amendments in criminal law, which redefined the concept of consent and strengthened legal protections against custodial rape. Following this, further legislative measures were undertaken to reinforce women's rights within the family and marriage. The Dowry Prohibition Act was amended in 1984 and 1986 to strengthen penalties for dowry offences. Family Courts Act 1984 was enacted to establish a specialized courts for speedy resolution of family disputes. Alongside these statutory developments, the judiciary played a crucial role in giving life to the spirit of equality enshrined in the Constitution. In the celebrated case of Air India versus Nargis Mirza, a group of air hostesses challenged discriminatory service conditions under the Air India Employees Service Regulations, particularly those that made them retire upon marriage if within 4 years of the service or on the first pregnancy or at the age of 35, whichever came earlier. The Supreme Court held that the rule mandating retirement on first pregnancy was unconstitutional and arbitrary, as it treated women unfairly based solely on sex, which was in violation of Article 14 of the Constitution. In Mary Roy versus State of Kerala, the petitioner challenged the Travancore Christian Succession Act, which discriminated against Syrian Christian women by giving them lesser inheritance rights than the men. The Supreme Court held that the Indian Succession Act 1925 applied also to the Syrian Christians of Kerala, thereby granting equal inheritance rights to women, affirming the principle of gender equality under Article 14. During this period, the judiciary also began to draw upon international human rights instruments to enrich and expand the interpretation of women's rights under the Indian Constitution. The courts recognized that the principles embodied in documents such as Universal Declaration of Human Rights, the Convention on the Elimination of All Forms of Discrimination against Women, and the International Covenant on Civil and Political Rights could serve as a persuasive source for advancing gender equality. By invoking these global norms, the courts infused constitutional interpretation with a broader moral and comparative perspective. In the landmark decision, such as Vishaka versus State of Rajasthan, the court called sexual harassment of women in the workplace a violation of the equality principle. The Supreme Court explicitly relied on SEDA to formulate binding guidelines against sexual harassment at the workplace, filing a legislative vacuum with principles derived from international law. This approach reflected on an evolving constitutional philosophy that the rights of women are not confined to domestic statutes, but are part of the universal struggle for dignity and equality. In doing so, the judiciary reaffirmed that India's constitutional vision of justice is in harmony with the global human rights movement, and that international law can be a catalyst for progressive transformation within our own legal system. The Vishaka judgment later led to the enactment of the Sexual Harassment of Women at Workplace Prohibition, Prevention and Redressal Act 2013. This legislation gave legal force to the Vishaka guidelines and made it mandatory for all workplaces to have an internal complaints committee. It marked a major step towards making workplaces safer and more equal for men. In Chairman Board, Railway Board versus Chandrima Das, the Supreme Court gave a powerful articulation of gender justice and human dignity under Article 21. The court emphasized that the protection of life and personal liberty extends to every woman, regardless of her nationality, social status, and legal identity. By recognizing that right to live with dignity belongs to all women within India's jurisdiction, the court underscored that gender-based violence is not merely a personal wrong, but a constitutional violation. The state, it declared, carries an affirmative obligation to protect women from such abuse and to provide effective remedies when that duty is breached. In affirming compensation to the survivor, the judgment marked a significant moment in the evolution of the gender-sensitive constitutional interpretation, where women's rights were viewed not only through the lens of individual justice, but as a collective reaffirmation of the state's commitment to the gender equality and human dignity. Now let me turn to the last 25 years. In this phase, laws and court judgments began focusing not just on preventing violence or discrimination, but on giving women equal voice and opportunity in every sphere of life. Issues like workplace safety, representation, reproductive rights, and equal pay came to the forefront. We saw the enactment of Protection of Women from Domestic Violence Act 2005, which provided the first civil law remedy for domestic violence in India. The Act defined domestic violence broadly to include physical, sexual, verbal, emotional, and economic abuse. It extended protection beyond married women to include sisters, mothers, and women in live-in relationships. The Act provided multiple relief mechanisms such as protection orders, monetary reliefs, and compensation. Following the brutal gang rape in Delhi in December 2012, the Parliament enacted Criminal Law Amendment Act 2013, which expanded the definition of rape and introduced stricter penalties for sexual offences. It also introduced new offences such as acid attacks, stalking, and voyeurism. It provided for the death penalty in cases causing death or vegetative state of the victim. The Maternity Benefit Act 2017 was also recently introduced. The amendment increased paid maternity leave from 12 weeks to 26 weeks for the first 2 children. The idea of gender equality also grew broader, embracing queer rights and inclusion of transgender persons in judgments such as Nalsa versus Union of India and Navtej Johar versus Union of India. Furthermore, the understanding of women's reproductive autonomy was reaffirmed in X versus the Principal Secretary, Health and Family Welfare Department, Government of NCT, where the Supreme Court expanded the scope of Medical Termination of Pregnancy Act. The court observed that the right to reproductive choice is an inseparable part of a personal liberty and bodily autonomy guaranteed under Article 21, and protection under Act was extended to unmarried women as well. The judgments like Babita Punia and Lieutenant Colonel Nitisha, to which I have already mentioned, the court paved the way of gender equality in the armed forces. Over the last 75 years, India has charted an extraordinary journey in advancing the rights of women and shaping the vision of an inclusive society. From the early struggles for recognition and equality to the present era of intersectional and participatory justice, the courts have often stood as the guardians of equality and human dignity. This evolution has not been without its challenges. There have been moments when judicial interpretations failed to capture the lived realities of women or fell short of the transformative spirit of the Constitution. However, the vigilance of civil society, the persistence of women's movements, and the courage of ordinary citizens have together kept the judiciary accountable to the constitutional promise of equality. Therefore, it is important to acknowledge that the progress in gender justice has never been the achievement of courts alone. The collective voice of the citizens has ensured that regressive precedents were questioned, debated, and ultimately corrected through reform, reinterpretation, or legislative intervention. The dialogue between the courts and the people thus remains one of the most vital sources of India's democratic strength, reminding us that the march towards gender equality is not a destination reached, but a commitment constantly renewed. Despite the progress we have made, the journey towards genuine gender equality remains far from complete. The task before us is not merely to celebrate symbolic achievements or token representations, but to ensure that women have a real and equal share in the space of power, decision-making, and opportunity. Equality must not be confined to numbers or appearances. It must be reflected in the structures, attitudes, and institutions that shape our public life. We must continue to dismantle the invisible barriers, social, economic, and cultural, that limit women's freedom and participation. The rights guaranteed by our Constitution must reach every woman, not just those in metropolitan cities or privileged contexts, but also those in small towns and villages and marginalized communities who continue to live at the edges of justice. True equality demands that the benefits of law, education, and opportunity extend to them in full measure. At the same time, achieving gender justice is not the responsibility of women alone. It requires an active reimagining of power by men, especially those who occupy positions of authority in our institutions, workplaces, and political systems. Real progress will come only when men recognize that sharing power is not an act of loss, but of liberation of society. The path to a gender-equal India, therefore, lies not in confrontation, but in collaboration, where men and women together rebuild the moral and institutional architecture of equality envisioned by our Constitution. Justice Sunanda Bhandare's contributions towards this journey are truly invaluable. She challenged prevailing societal norms and urged the judiciary to develop a deeper understanding of gender justice and equality. Her resolve to build a society where justice is not just a distant ideal, but a goal that can be achieved through empathetic and compassionate lawyering, has deeply influenced the trajectory of the Indian judiciary. And I am confident Justice Bhandare's legacy will continue to create ripples as India navigates more challenges of social equality in the legal realm. Thank you very much. Thank you for giving me this opportunity and bearing with me.
Thank you, Justice Gavai. When my grandfather set up the Justice Sunanda Bhandare Foundation, it was to fulfill my grandmother's dream of a gender-equal India. In truth, it was as much his mission as it was hers. But the foundation stands also as a testament of one man's love and devotion to his wife. It's this devotion that has sustained the foundation, a shared belief in social equity by all our speakers who have so generously and enthusiastically supported us along this journey that's now 31 years old. We wouldn't be here without them, so my first thanks to all of them. We're eternally grateful. This year's speaker, Chief Justice Gavai, follows the same path of generosity. As my grandfather often said, with little persuasion from our side and no hesitation from his. His profound words and keen insight on inclusion and equity gives us food for thought and adds intellectual depth to the issue. Thank you, sir. Thank you also to Delhi High Court Chief Justice Upadhyay for presiding over the 30th Memorial Lecture. It's also the second after the passing of my grandfather, and it means a lot to us that you agreed to be here. Thank you, Justice Madan Lokur, our foundation's chairman and guiding light. Many thanks to our media partners at Live Law, Bar and Bench, Leaflet, as well as all media present to cover this significant talk. And above all, our gratitude to all of you who have attended and been our companions in this journey to gender equality. Thank you.
Yes. Yeah, no. In fact, they have confirmed their office already. Thank you.
Thank you. Thank you, Chief Sir.
Thank you, Chief.
Sir.
Oh.